Hey everyone, it's Rob Ryder, and today is Sunday, November 8th, 2020. Veterans, rally at Rule 40. I think that's what we need to try to do, and that's what this video is about, is the Supreme Court of the United States Rule 40 and how it applies to veterans, seamen, and military cases. And before we get there, I'm Staff Sergeant Robert Allen Rytlewski, United States Army veteran, also known as Rob Ryder. My email address is courtofrecord@aol.com. No S's on the words, right? Court of Record. And I forgot to put my address and phone number on, but I normally do, so it would be on one of my past videos. And thinking of that, if you were to, because I can't really go back and talk about all the things I've already done in this record, it'd take too long. But if you went back as far as miscellaneous cases in the mother court, which was about a month ago now, right, it would cover all the little details I'm talking about now. But we don't need all that for the things I really want to talk about. So this is what's going on, though, right? That there is this rule in the Supreme Court of the United States Rules, Rule 40, Veteran Seaman Military Cases, where it says, a veteran suing under any provision of law exempting veterans from the payment of fees or court costs may proceed without prepayment of fees or costs or furnishing security, therefore, and file a motion for leave to proceed on papers prepared as required by Rule 33.2, which is basically saying on 8.5 by 11 paper, double spaced when you're speaking, indented and single spaced when you're quoting. Right, those are the rules. The motion shall ask for leave to proceed as a veteran to be accompanied by an affidavit or declaration setting out the moving party's veteran status. A copy of the motion shall proceed and be attached to each copy of a petition for writ of certiorari or other substantive document filed by the veteran. Right? So I'm not looking for a writ of certiorari, obviously, but I do know that looking at the Supreme Court rules and looking at historic rules in the Supreme Court, that it's from the very first days said that it's a court similar to the Court of King's Bench and the Court of Chancery, right? So it has both jurisdiction in law and in equity. And I know I need an equitable remedy because I need some kind of injunction. I'm not looking for damages specifically, although, I'll take the damages. But if you want to get something changed or fix a document or a record or whatever, that can only be done in equity. And that's really what they've been hiding from us. And here in the last few weeks, I had read that the Supreme Court writes rules, or it's given by Congress the authority to write rules for the other courts. So since this is just a rule of the Supreme Court, and it doesn't say that this is in the Supreme Court, then this should apply to any other court that the Supreme Court can write rules for, like the district court. Right? And so that's what because I already had a case open in the district court, I went ahead and I used that as my putting my motion for leave in to file as a veteran under the Uniform Code of Military Justice for redress of grievances having to do with my property. And we'll look at it exactly what it was. And I filed that last week. And it took a couple days, but the chief judge just here in the last couple days, what's today, Sunday? I guess it was Friday, put a note into the docket that she had sua sponte reassigned the case because she had the case, right, to a single judge who's like this, let's call him the senior district judge of the, Southern District of New York. And the reason I say that is, the guy's 94 years old. He was appointed by Reagan in 1985, had been an attorney for 30 years before that, and had been a member of the Merchant Marines, or he was actually a cadet in the Merchant Marines. I think then they closed down the school right after World War II, and he went into the Marine Reserves, right? So he's the guy that has my petition about things to do with my military service, that there's errors in my records that are keeping me from getting, what's due me. And, we'll show you what that is. So that would be one thing to use it for, but there's this other rule, right? So I was thinking, well, what else could this thing be used for? Well, right, in Title 38 United States Code, Section 503, administrative error, equitable relief. It says if this is the VA now, right? If the Secretary determines that benefits administered by the Department have not been provided by reason of administrative error on the part of the federal government or any of its employees, the Secretary may provide such relief on account of such error as the Secretary determines equitable, including the payment of monies to persons whom the Secretary determines is equitably entitled to such monies, right? Like a survivor. So, right, that's 38 USC 503. Now, I know, I know in my own family, my brother, he, according to the disability ratings, could get unemployability because he has a 60% disability rating for one disability, right? And according to we'll look at it right now. According to the rules, that's enough for him to get disability. All right, 38 CFR 416. This is talking about total disability ratings for compensation. Well, let's go to the beginning. Total disability ratings for compensation based on unemployability of an individual. Right? A total disability rating for compensation may be assigned when the scheduler rating is less than total, when the disabled person is, in the judgment of the rating agency, unable to secure or follow a substantially gainful occupation as a result of service-connected disabilities, provided that there is only one such disability, this disability shall be rated at 60% or more. And that if there are two or more disabilities, there shall be at least one disability rated at 40 or more, and a sufficient additional disability to bring the combined rating to 70%. Right? So if you got 60% for one or a total of 70, with one being more than 40, that's good enough to get unemployability. 100% disability payment. It's like, $3,000 a month as unemployability. Right? Well, they won't give it to him. And my brother-in-law has a friend down in Florida, same thing. Wouldn't give it to him either, right? But this is what it says. And then it goes on to say, it is established policy of the Department of Veterans Affairs that all veterans who are unable to secure and follow substantial gainful occupation by reason of service-connected disability shall be rated totally disabled. Therefore, rating boards should submit to the Director of Compensation Services for extra scheduler consideration all cases of veterans who are unemployable by reason of service-connected disabilities, but who fail to meet the percentage standards set forth in paragraph A of this section. So this would be everybody who has something less than 60% for one, but still unemployable. Right? So how do you determine if you're unemployable? And then, so there's another one, total disability rating for pension based on unemployability and age of individual. So there's reasons here to say, well, this wasn't being followed. So it's an error. And according to this rule, I should be able to take it to the Secretary of the VA and say, hey, man, you got to fix this, right? There's administrative errors by federal employees. So that would be another, case to take to somebody to have them, because this is, Title 38. So a federal judge enforces federal law. Well, this is a federal law. So that judge, get the secretary to, give me some equitable relief. Right, so that's possibly how it could be used. Now, I wanted to show this, though. So, right, 21(1)MR, Part V, Subpart II, Chapter 1, Section B, determining disability, unemployability, and marginal employment, right? This is what they say. And so we just go with what they say as our evidence. And they say, in many instances, the veteran's unsupported statement will be enough evidence to establish unemployability, even if it is consistent with other facts of the case, such as a good work record. But this is the point. A veteran's unsupported statement will be enough evidence to establish unemployability. It doesn't have anything to do with how disabled you are. It's that you say you're unemployable. Can't do it, right? I just can't do it. And here's why you can't. Right? If we just look at the way they write these things, right? When unemployability is established, inability to secure and retain substantially gainful employment by reason of disability as well as other factors. Substantially gainful employment. So what does that mean? Is employment that is ordinarily followed by non-disabled. Well, you're disabled. You can't do it, right? You can't fit that definition because substantially gainful employment requires you to be non-disabled. So, I'd say that's enough reason right there. And I say I can't do it. So I just as soon take the $3,000 a month and not put up with the bullshit. So this is, it's a big deal. There's a lot of people sitting around, 70%, which is maybe $1,700, which, have the right to have $3,000 a month. But when you go through normal channels, it doesn't work. Right? You can't go to the VA to take care of this. You can't, there's everywhere you go seems to be a roadblock. That's why I say, well, maybe this is the end of the roadblock, is to just do it by Rule 40. So like I said, there's another one that this is what I did, right? So again, I didn't put mine into the Supreme Court, but if I did another one, I would, just to see how it is. But I already have this court case going that I'm saying, look, there's all sorts of errors in they call it the DEERS record, right? That is used by the VA and your branch of service to determine your eligibility for A, B, and C. Well, one of those A, B's, and C's is an identification card. All right, so if you had that identification card, it would be a Geneva Convention identification card, right? And you wouldn't be screwed with by the locals anymore. You would be back in the military. You just say, take me to the post. You don't have any jurisdiction. I'm under the UCMJ. And that would be the evidence, right? Now, you are under the UCMJ, but right now you don't have the evidence. So what I did is I made up this little, this is like the sixth document here, so this isn't the first piece of paper to go in this court case, but notice of motion of leave to proceed as a veteran suing under the Uniform Code of Military Justice, Article 139, redress of injuries to property. Right, and here's the Rule 40, and I put a declaration that I, Robert Allen Radlewski, with my DOD ID number, declare I am a veteran, member of the Armed Forces of the United States, a person subject to the Uniform Code of Military Justice, petitioning the government for the redress of injuries to property by members of the Armed Forces under Article 139 of the Uniform Code of Military Justice, which is 10 U.S.C. Chapter 47. Right, so this is Title 10 we're talking about. This is, again, in the military, we call it the UCMJ, but it's Title 10 or part of Title 10 of the United States Code. And a district judge has the authority to enforce the freaking district code or the U.S. code. That's what it's for. And right, if you're doing a declaration, you're supposed to, this is for an unsworn declaration, you put, I declare under penalty of perjury the foregoing is true and correct. Executed on whatever date, right? This comes out of 28 U.S.C. something or other, which gives you two choices. One in the United States, one within and one without. And I'm saying I'm within, and this is the style for within. If it's without, it says the rules under penalty period foregoing in the laws of the United States of America or something like that. But hey, this is Title 10, right? If this is Article 139, right? But it's 10 U.S.C. 939. Whenever a complaint is made to any commanding officer that willful damage has been done to the property of any person or that his property has been wrongfully taken by members of the armed forces, he may, under such regulations as the Secretary concerned may prescribe, convene a board to investigate the complaint. The board shall consist of 1 to 3 commissioned officers, and for the purpose of that investigation, it has the power to summon witnesses and examine them upon oath, to receive depositions, or other documentary evidence and to assess the damages sustained against the responsible parties. The assessment of damages made by the board is subject to the approval of the commanding officer, and in the amount approved by him shall be charged against the pay of the offenders. The order of the commanding officer directing the charges herein is authorized conclusive on any disbursing officer for any of the payment by him to the injured parties for the damages so assessed and approved. If the offenders cannot be ascertained, but an organization or detachment to which they belong is known, charges totaling the amount of damages assessed and approved may be made in such appropriation. Yada, yada, yada. So, in my case, it's the U.S. Army's Human Resource Command that is that's where the records are incorrect, right? So it's being done by a member of the armed forces. And as I've shown before, hang on a second. Right, when I go to my, look myself up in the VA, it has my name as Robert Allen Rytlewski. Now, when I first, to get this here, you have to have a DEERS account, right, with DEERS. And that's where the error is, because that's where this comes from. And when I first got it, it had Robert A. Rytlewski in it, and I wanted to complain, so I called the number, and they said, oh, you got to talk to DEERS. Oh, you got to mail something to this place. And I did, and I told them, hey, I don't have a middle initial. I don't have a middle name. I have a given name. My given name's Robert Allen, right? I don't have a middle initial. Well, this is what they gave me, for the trouble. Robert Allen Rytlewski. But that isn't the only thing that's wrong. My birth date is wrong, right? So it should be September 5th. It's September 1st. Duh. Well, okay. And it has my service dates wrong. Right? My DD-214 says, I have two of them. One says March 16th. The other one says January 11th. But this says the 17th and the 22nd. So, this record isn't me. So where am I? How come I'm not in there? What happened to me? Who's this guy? Right? This is the guy getting whatever benefits there are, but it really isn't me. So, these are errors in a record kept by the VA. So there's no reason that I couldn't use, the law I just showed you under 38 U.S.C. 503, right? It's administrative error. But I decided instead, because of the way the rule was written, and I already had the paperwork in, that a veteran suing under any provisional law exempting veterans from payment of fees, well, I'd say if we can all agree I'm under the Uniform Code of Military Justice, I wouldn't have to pay any fees to bring an action under Title 139. In fact, I think a civilian can do this. Right? And the United States is in a military jurisdiction, so every place you see a gold fringe flag, that's military. And anybody who accompanies the military into the field, right, in a time of war is under the UCMJ. Well, that would include all the people pretending to be governors, congressmen, senators, right? Judges. They're sitting there with a gold fringe flag. That's military jurisdiction. The church, they got gold fringe flags, right? They were given a commission. The Protestant churches and the Catholic Church and the Jewish organization were all given commissions by the Department of War, right? Not a civilian commission. No, a military commission, just like a military officer. And the war's never ended, right? So their commissions are still in effect. So that's what's going on, right? That these people that we think are the government, from Trump on down, haven't taken the oath of office to satisfy the 6th article of the Constitution. So they're not officers of the United States at all, right? They are in a parallel jurisdiction. Let's call it United States of America, which would be King George III's survivors or successors jurisdiction, right? Some corporate jurisdiction, but it's not the United States, and it's not under the Constitution. But you could, by free association, be a member of that, and then you would have to adhere to its rules. Well, that's where they took us, right? Without us wanting to go there, we've been coerced to going to their jurisdiction. But it isn't the jurisdiction of the United States. The jurisdiction of the United States is under martial law, under military rule, and these judges have the authority to enforce military law because it's under Title 10 United States Code. So that's what I'm going to try. And like I said, thank God that, let's see if I have it here. Yeah, so when I put this into the court case, right, it generates this electronic notice or service, right? And it was the first time where it came back to say something about in the subject line that it had to do with motion for miscellaneous relief. Right? I didn't really say that, but that's what they put in there. So it's a motion for miscellaneous relief in the U.S. District Court. Well, U.S. That's a military abbreviation for the United States. So notice and motion for leave to proceed as a veteran suing under the Uniform Code of Military Justice, Article 139, redress of injuries to property, which is 10-939. They put that in their computer coding system. Document filed by myself. Right? So that's what was put in, and that generated this. There's no paper trail for it. It's just, right? Notice of case reassignment, sua sponte, to Judge Lewis L. Stanton by Judge Colleen McMahon is no longer assigned this case. Well, she's the chief judge. She's the chief United States District Judge. Right? Not chief United States District Court Judge, the chief United States District Judge. Now, she's not the only one. You can Google that phrase, chief United States District Judge, and it looks like all the people we would say, well, that's the chief judge of that particular federal district, is who they're talking about. Right? But it's chief United States District Judge, as in United States District. Right? The territory. Put her in a different hat. And then what she did is she, as it says to do under, the article, right? If she was the authority, then she could convene a board of 1 to 3 commissioned officers. And, when you go and look, federal judges have a commission, right? They get commissioned by the President of the United States, so they're a commissioned officer. So, again, this was all just last week. This will all show itself to be true or just more smoke and mirrors by itself. Not much more I can do except wait to see what Lewis L. Stanton does. But, for anybody else that has a situation where, if you're 70%, you're trying to get your 100% disability, well, I think that's what this is saying, is that, you just file it into the Supreme Court. And so these are things I'll be working on over the next week. But I know there's vets that have really, really good contacts. Do any people know a freaking attorney you could take this to? I mean, that would tell us the truth, or a high-level commissioned officer to say, what do we need to do, sir? All right, just somebody give me a 1, 2, 3, and I'll go do it. Until then, I'm just poking around because I don't know what to do. But I know that if you're going to let me file for free, I'm going to go ahead and try. Okay, that's really all I wanted to say was, Rule 40, take a look at it if you've not done it before and apply it to your own situation, right? One piece of paper that says it's a motion asking for leave to file as a veteran. And then whatever your affidavit or your petition is, right, your sworn statement or whatever it is, and submit it to the Supreme Court and see what they do with it. And let me know. Good, bad, or indifferent. Okay, God bless all. Have a good day.